The topic for today is, as you all are aware, admissions and denials under the Code of Civil Procedure 1908. Now, what is this admission? What is this denial? We'll go from the basics of it and we'll understand the elements of it, various other facets of it. But before that, I need to take you not to the CPC, but to the Evidence Act. But even before that, I would like to share an instance, because you see, this is a topic which is more or less a dry topic, I must admit it. Not only it is a dry topic, but no good material is available, unfortunately so, on the internet or in the books available on this particular chapter. So we will have to study it on our own, enhance it, educate ourselves, and expose ourselves to this particular topic and the jurisprudence surrounding it. Let us go. The instance goes in such a manner. It was a case in which I had the fortune of appearing. One particular trust which owns a particular building, it is the owner of a particular building. Some member of the trust who is a troublemonger, without the permission of the trust, rents away or leases away the building to some different trust altogether, and tells that trust, you conduct educational activities, I have the authority to sign any agreement, be it lease agreement, rent agreement, any agreement on behalf of my trust. He does so without authority, but he does so. Now this agreement so signed for rent is of 30 long years. Now 30 long years is the agreement. That agreement is still in existence as per what the trust occupying the building says. They go to the court for a bare injunction because we try to remove them. We try to disturb their possession because we come to know that this agreement, we had never authorized anybody to sign such kind of an agreement. How can you go ahead with such an agreement? You are not entitled to stay into those premises. Get out. They go to the court and seek an injunction against us, that we are here on the basis of an agreement signed between me and some authorized representative of the trust. Today, they say that the man had no authority to sign on behalf of the trust. But today, we have this agreement in our hand. So far, so much. But tomorrow, when we see the agreement, we come to know that this agreement has already expired in the year 2022. So assuming, for the sake of assuming, that this agreement was valid when it was made, though it was not, but assuming for a second that it was valid, today it has expired. So can you stay in the premises on the basis of an expired agreement? That is the question before the court. So the court asked me, are you ready to admit the existence of such a document? I said, yes, I admit the existence of such document. Then the other side jumped. The other side said, if they admit the existence of such document, then we have the authority to stay here. That is the difference. When I admit the existence of such a document, I do not admit the contents or mainly the veracity of the contents of the document. So mark this difference very carefully. Admitting the document is one thing, and admitting the execution of the document is another thing. A recent judgment of the Supreme Court, what had happened was that a particular lady had given away her development rights in favor of a particular developer. The developer later on turned his back and said that there are some more development agreements which are signed between you and me, and this is your signature. Matter went up to the Supreme Court. The lady said that, yes, this is my signature. Then the developer's advocate said that if that is your signature, then you agree with the contents of the document if you have made this signature. Supreme Court said, no, sorry. It was a 3-judge bench of the Supreme Court headed by Justice Chandrachud. It said that mere signing or mere admitting of the signature does not lead to admission qua the contents of the documents as also the execution of the documents. This is something interesting, where on one hand, a person has the liberty to admit or say yes to the signature, his or her signature on the document. But at the same time, he has the liberty to say no to the contents and veracity of the document. This is something interesting, and which is why we learn this. I would like to share my screen so as to not show you the CPC, but show you the Evidence Act. You must be wondering why I'm showing you the Evidence Act, but there's some relevance to it. Now, what you see over here is public documents, section 74. This is Evidence Act, public documents. Now, documents can be of two types. It's either public or private. Now, why we speak of documents? Because when we speak of admission, it can only be admission qua documents. Because as you all are aware, that evidence in a court of law can only be of two types. One is oral evidence and the other is documentary evidence. Here we stick ourselves only to documentary evidence because we are concerned with admissions, and admission can be of documents. So see, public documents. The following documents are public documents: documents forming the acts or records of the acts of a sovereign authority, two, of official bodies and tribunals, and of public officers, legislative, judicial, and executive of any part of India or the Commonwealth or of a foreign country. This is okay. What all that it says is that governmental records, governmental acts are public documents. No difficulty. Second is very important. Public records kept in any state of private documents. Just try to understand what this is. Public records kept in any state of private documents. So it is a private document, but it should be kept in public record. It becomes a public document. There is a slight controversy on this. Take a case of a registered sale deed, where you and me enter into a transaction of sale of a particular flat, and we get it registered before the sub-registrar. Does that document become a public document? Can any Tom, Dick, and Harry visit the sub-registrar's office and ask for that document saying that, please see section 74, it is a public document, I'm now throwing in an RTA and I want that public document? Can it be possible? Some jurists say that yes, it is possible in light of section 74. Some say, sorry, that document by itself is not a public document. Please read what it says. Public records kept in any state of private documents. It does not say that private documents kept in public records. What it says is public records kept in any state of private documents. So the second set of jurists say that only the registers or the entries of those sale deeds or gift deeds or whatever, transaction deeds, conveyances, etc., registrable documents, only the records of the documents and not the documents by themselves are public records. Second, we come to section 75, that is private documents. All other documents are private documents. So anything that is not included in section 74, the above provision, is included in section 75. So bear that in mind. What is a public document? What is a private document? Now, once we understand this categorization of document, we then go to section 91. We'll go to chapter 6, Evidence Act, section 91. Evidence of terms of contracts, grants, and other dispositions of property reduced to form of a document. So suppose there is a contract in existence, or there is any other will in existence, or disposition, or any some document which is in existence today, and you produce it before the court. Now, what is the proof of that document? The court may ask you. So this Evidence Act tells us that why do you need any other proof when you have the original document by itself in front of you? So when the document, the original document is in front of you, why do you need any other proof of the existence of that document? Suppose a tenant comes to the court saying that the landlord is now dispossessing me despite me being in lawful occupation. The court will ask, all right, what do you have to show? The classic document that he would produce before the court is the leave and license agreement. Once he produces the leave and license agreement in the original form, as it may be, the court will have to assume that this is a leave and license agreement. But read this section carefully. Merely because the landlord tomorrow admits the existence of the document does not make him admit the veracity or genuineness of the document. So the argument of genuineness or veracity is always open. Bear that in mind. I want to take you straight away to the CPC. We will be specifically dealing with Order 12 and somewhat with Order 11 as well of the CPC. You are aware about the elements of a trial, a civil trial, how it goes. A plaint is instituted, praying for some reliefs, whatever the reliefs may be, either declaration or injunction, partition, so on and so forth. It broadly has to be either a declaration or an injunction. Some may say, what about partition? Some may say, what about this, that? Ultimately, it's a declaration. So it is either a declaration or a bare injunction suit, an injunction claimed without any declaration, rightly or wrongly. So either declaration or bare injunction. So in that suit, the main relief is of declaration, second relief is of a temporary injunction or a permanent injunction, third relief is of a temporary injunction, so on and so forth, costs, etc. Now, in support of the document, that is the plaint, you have the pleadings in your plaint. In support of that plaint, you have some documents in favor of the plaint. Those documents are the ones where admissibility comes into play. So suppose tomorrow there is a leave and license issue between the landlord and the tenant. The tenant comes with a case to the small causes court that this is the agreement and my landlord denies the existence of this agreement. He says that I have trespassed into his property and I have never ever paid him rent. There was no transaction whatsoever between me and the landlord. And now he is dispossessing me, that to forcibly from my house. This is what the tenant says, tells to the court. Tomorrow, if the landlord comes before the court and the landlord says, yes, this is the agreement which was signed between me and him, finish, the game is over. The suit is over. The suit has to be decreed in the tenant's favor, because the ultimate argument of the tenant was that this is the agreement on the strength of which I have entered into this contract with my landlord. And today, if he denies this, then I will have to proceed to framing of issues. And then the issues will have to be tried. Testimonies will have to be deposed. And then the decree will be passed, ultimately as per the provisions of law. Then the decree will have to be executed. But today, if at this instance, the landlord says, yes, this is my agreement, I have signed it with this very man, accepting me as my tenant, then the play is over. Then the court need not waste its time by going into evidence and framing of issues, etc. So the legislature, mind you, has been very smart enough to place this order before the portion of framing of issues. So once the issue of admissibility or denial gets over, it is only then the court will come to framing of issues. The court will frame issues, and on the issues, the court will tie evidence. I just wanted to show that all the documents should be produced before the court at the first instance. That is what Order 13 says, but we'll come to Order 13. See what first rule of Order 12 says. Notice of admission of case. Any party to a suit may give notice by his pleading or otherwise in writing that he admits the truth of the whole or any part of the case of any other party. So here, the plaintiff or the defendant is required to give notice to the other side that, see, that a particular document, I believe you must admit it before the court because you have no business in disputing it. And if you believe so, then you please come to the court and accept it. Tell the court that I accept it. So this is as per Order 12 Rule 1, we give a notice to the other side. Either you being the plaintiff or the defendant, you give a notice to the other side, asking the other side to say yes or no, one of it, to the document. If he says yes, the suit is decreed, if that is the nature of the suit. If he says no, then issues will be framed and the suit will go for the trial stage, the evidence stage. The issue will be tried, issue will have to be tried, tested. The second rule again, notice to admit documents. Either party, look at it, it says either party may call upon the other party to admit within 7 days. 7 days is the stipulated time from the date of service of the notice any document, saving all exceptions, and in case of refusal or neglect to admit after such notice, the costs of proving any such document shall be paid by parties so neglecting or refusing, whatever the result of the suit may be, unless the court otherwise directs, and no costs of proving any document shall be allowed unless such notice is given except where the omission to give the notice is, in the opinion of the court, a saving of expense. So beautifully drafted. What it says is that you give the other side a notice, call upon the other side to admit a particular document which you are desirous of that he should admit. Let him say yes, let him say no. If he says yes, it's fine. If he says no, then also it's fine, you proceed as per law. But if he refuses or neglects to admit it, he does not respond to it, he does not give any answer, he just refuses to look at the notice that has been issued by you, then what will happen? The court says that he will have to pay the cost, whatever the disposal of the suit may be, whatever the decree may be in anybody's favor, he or she will have to pay the costs. Why? Because he has refused or neglected. Why do you refuse? If you have good grounds, then don't refuse. You tell the court or you tell the other side who has issued the notice, you tell that I am the noticee, I believe that I should deny it, or I believe that this should be partly denied. Don't refuse or neglect, because that is, you are causing harm to your own case. This is interesting. Section 2 capital A. Document to be deemed to be admitted if not denied after service of notice to admit documents. Every document which a party is called upon to admit, if not denied specifically or by necessary implication, or stated to be not admitted in the pleading of that party or in his reply to the notice to admit document, shall be deemed to be admitted except as against a person under a disability. So here the deeming provision is given. I told you about the harm that you may cause to your case. This is the harm. Rule 2A is the harm, which says that it shall be deemed to be admitted, provided that the court may in its discretion and for reasons to be recorded require any document so admitted to be proved otherwise than by such admission. This goes somewhere beyond the principle of admission, where the court has been given a supplementary discretion that, all right, this appears to be admitted, but still I want to try it. Still I want oral evidence in favor of it. So the court can do it. So mere admission, mere denial doesn't work. Here the court says that, so what? We will try it and we will call upon oral evidence in support of it. So you prove it by way of oral evidence or by way of other documentary evidences. All right. See what 2A2 says. Where a party unreasonably neglects or refuses to admit a document after the service on him of the notice to admit documents, the court may direct him to pay costs to the other party by way of compensations. This need not be explained. Rule 3, form of notice. A notice to admit document shall be in form number 9, that you please take a look at form 9 in appendix C, with such variations as circumstances may require. So there is a form in which notice will have to be issued, and that is the form. That is what rule 3 says. 3A determines the power of the court to record admission. The court has been given enormous power to record admission. Look at it very carefully, section 3 capital A. What it says is that at any stage, it starts with a non-obstant clause, notwithstanding though that no notice to admit documents has been given under rule 2, the court may at any stage of the proceeding before it of its own motion call upon any party to admit any document and shall in such a case record whether the party admits or refuses or neglects to admit such document. Suppose in this case the party refuses or neglects, then we go back to the deeming provision. If you recollect the deeming provision where a party refuses or neglects, then there shall be a deemed admission. Despite the deemed admission, the court can say, no, produce oral evidence or produce other documentary evidence. Despite all of that, suppose if you as the plaintiff or as a defendant do not call upon the other side to admit a document, the court has the power under section 3 capital A to call for admission of that particular document. Then comes rule 4, notice to admit acts. Any party may, by notice in writing at any time, not later than 9 days before the date fixed for the hearing, call on any other party to admit for the purposes of the suit only any specific fact or facts mentioned in the notice, and in case of refusal or neglect to admit the same within 6 days after service of such notice or within such further time as may be allowed by the court, the costs of proving such facts or facts shall be paid by the parties or neglecting or refusing, whatever the result of the suit may be, unless the court otherwise directs. provided that any admission made in pursuance of such notice is to be deemed to be made only for purposes of that particular suit and not as an admission to be used against the party or any other occasion or in favor of any person other than the party giving the notice. Now, this is something very, very interesting. Here, it repeats what the earlier provisions say, but ultimately it goes on to compile that in case of refusal within the stipulated time period, in case of neglection within the stipulated time period, whatever the case may be, he or she will have, whatever the outcome of the suit may be, in whosoever's favor the decree may be, he or she will have to bear the cost paid to the other side, etc. The fact being that more than the parties, the court has been given power to call for, even suo motu, invite a party to admit a particular document, and if the party doesn't do so, then the court can proceed as per rule 4. That is what the rule says. Now you see there are various forms of admissions. If you see rule 5, a notice to admit fact shall be in form number 10 in appendix C, and admissions of fact shall be in form number 11 in appendix C with such variations and circumstances may require. This is important. Rule 6, judgment on admission. Because ultimately, why do we do all this? It is for the judgment of the court. So if the court so believes that on the basis of a particular admission, the suit can be fairly decreed, the suit can be disposed, you need not go into the evidence stage, you need not frame the issue. The court will pass the judgment then and there on that particular issue of admissibility and also the entire suit. So your judgment on admission, where admissions of fact have been made either in the pleading or otherwise, whether orally or in writing, the court may at any stage of the suit, either on the application of any party or of its own motion, without waiting for the determination of any other question between the parties, make such order or give such judgment as it may deem fit, having regard to the admission. So probably there may be a dozen of issues before the court. But even if one of the issue is getting settled, one of the issue is getting decreed because of this particular admission, the court has the power to do so. Then comes affidavit of signature, etc. Then there is notice to produce documents. This is something important on the practical arena. Because you see, today we live in such kind of a world where in order to obtain a particular decree, parties go to any extent of manufacturing documents or even hiding documents, what we in legal language call as suppressing documents. Best example is that of a husband-wife dispute for maintenance. The wife wants to tell the court that she is the poormost woman in the entire world. The husband wants to tell the court that he is also the poormost man in the entire world. Wife wants more and more maintenance. The husband doesn't want to disclose his income sources, and he wants to give the lowest possible maintenance that the court may award him. This being the case, tomorrow if the husband is not going to disclose all his income sources, or if the wife is not going to disclose all the income sources, recently the Supreme Court, I believe you must be aware, the Supreme Court has said that the husband and the wife both should give affidavit of assets and liabilities. In that affidavit also people lie, they suppress so many things. So tomorrow if your client tells you that as a matter of fact, sir, I know that this wife of mine is earning more than what she shows. And in fact, my daughters are staying with him. My daughters are staying with her. And one of the daughter is a CA. The other daughter happens to be a professor. And both of them are earning well. The mother is having a lot of cash with them. So have the income certificates of the daughters. Obviously, the wife is not going to attach the income certificates of the daughters to the affidavit, but as the husband, you can ask the court to issue directions that let them produce these documents before the court so that it will be a fair deal between the parties. Here, as a private party to the other private party, you can call for those documents for production. Notice to produce documents. Rule 8 I am reading. Notice to produce document shall be in Form 12 in Appendix C with such variations as circumstances may require. An affidavit of the pleader or his clerk of service of any notice to produce at the time so and so. So basically, it should be supported by way of an affidavit that you have given a notice to produce certain documents which are not in your custody. Then Rule 9 deals with costs. Then we come to Order 13, production, impounding, and return of documents. The CPC requires, or for that matter, any other litigation system in the world requires, that you should come with clean hands. You should come with everything and anything that is there in your possession relevant to the case of yours that you come to the court with. This principle is known as uberema fides. Uberema fides is come with clean hands. Don't hide anything from the court. You know, insurance policies, there are so many instances where insurance claims get rejected for unjust reasons. So suppose a person who dies with COVID, they tell him that your insurance claim, they tell his wife or the relatives that now we are not going to clarify, we are not going to release the claim amount because you did not disclose that your husband had diabetes or your husband was suffering from hypertension. Now the wife tells the insurance company that he has died of COVID and you are telling me that we did not disclose that he died of hypertension. You are telling us that he did not disclose his disease of hypertension. How is that even interrelated? But then the insurance company says that we work on the principle of uberema fides, where you will have to come with clean hands and you will have to disclose everything and anything that you know. We will decide whether it is connected or not, but you will have to disclose anything and everything. The civil court also believes so. The civil court says that disclose everything and anything. And that is what Order 13 Rule 1 says. Original documents to be produced at or before the settlement of issues. The parties or their pleader shall produce on or before the settlement of issues all the documentary evidence in original where the copies thereof have been filed along with the plaint or written statement. The court shall receive such documents so produced, provided that they are accompanied by accurate list thereof prepared in such form as the High Court directs. Nothing in Subrule 1 shall apply to documents produced for cross-examination of witnesses of the other party or handed over to a witness merely to refresh his memory. Rejection of irrelevant or inadmissible documents. Rule 3 I am reading. The court may at any stage of the suit reject any document which it considers irrelevant or otherwise inadmissible, recording the grounds of such rejection. Rule 4 is very important. Pay attention. Many people ask me to speak upon this particular aspect. How do you admit and how do you deny? And in what methodology do you do? As in, what should be the exact mechanism? What should be the exact sense in which you can say that, yes, I have admitted, and you can say, yes, I have denied. Before you read Rule 4, just see Order 8, Rule 4 and 5. What is Order 8? Order 8 deals with filing of written statements. Now here, when as the defendant you file written statement, you will have to annex all these documents in favor of the written statement. And you cannot say that I am now relying upon the plaintiff's documents. Of course, you can always rely upon the plaintiff's documents if they are so supportive to you. But you can't say that just because the plaintiff has not annexed something, I will also not annex something. He has suppressed something, I will also suppress something. That is not how it works. You will have to annex anything and everything that is in your favor to the written statement. All right. And even against probably. All right. But here, you will have to give a parawise denial to the plaint. The plaint is of 40 paragraphs, where 30 paragraphs are dealing with averments and allegations or apprehensions or whatever, the cause of action. You will have to deal with each and every paragraph, not mechanically, but substantially and fully, so to say. Suppose if the tenant in the plaint says that I have been lawfully residing in the premises for last more than 40 years. Then you can't just say in your written statement that no, he has not been residing in last more than 40 years. He is wrong. He is lying. You can't say that in your written statement. You will have to say that, but along with that, state reasons. Tell the court as to what is your explanation. So that is what Order 8, if you remember, I took you to Order 8. Order 8 Rule 4 says that no evasive denial. It has to be a specific denial. What do they mean by specific? Give a reasoned denial. Say that these are the reasons that for which I am denying the allegation. These are the reasons for which I differ with the allegations or the averments made in the plaint. So the essence of all this is, it probably all these provisions are differently worded, but the essence of all this is, come with clean hands and be reasoned and reasonable too. See Rule 4, endorsements on documents admitted in evidence. Subject to provisions of the next following sub-rule, there shall be endorsed on every document which has been admitted in evidence in the suit the following particulars, namely the number and title of the suit, the name of the person producing the document, the date on which it was produced, the statement of its having been so admitted, and the endorsement shall be signed or initialed by the judge. Next is also important. Where a document so admitted is an entry in a book, account, or record, and a copy thereof has been substituted for the original under the next following rule, the particulars aforesaid shall be endorsed on the copy, and endorsement thereon shall be signed or initialed by the judge. All this is okay. All this deals with documents which are admitted in evidence under Order 12, the earlier order, if you remember. But how do you actually admit it or deny it? There are certain elements. You either admit or deny the contents of it. You either admit or deny the existence of the document. You either admit or deny the execution of the document, or you either admit or deny the issuance of receipt of such a document. So first is, you admit or deny the correctness, you admit or deny the execution of it, you admit or deny the issuance or receipt of it, or you deny the contents of it. So it will not be so that you give an evasive denial, you give a very summary denial or a cursory denial. It will have to be a proper and non-ambiguous denial. That is what the CPC requires. Now, this being the position, let us come to something more interesting. Return of admitted documents. That is Rule 9, Chapter 13. Any person, whether a party to the suit or not, desirous of receiving back any documents produced by him in the suit and placed on record, shall, unless the document is impounded under the earlier provision, that is Rule 8, be entitled to receive back the same. A, where the suit is one in which appeal is not allowed when the suit has been disposed of, and where the suit is one in which appeal is allowed when the court is satisfied that the time for preferring appeal has elapsed and no appeal has been preferred, or if the appeal has been preferred when the appeal has been disposed of. So here the original documents so impounded by the court, not impounded. If they are impounded, then they cannot be returned. But the documents which are produced before the court and admitted, and on the basis of that admission, the suit came to be decreed. If the documents you want back, then subject to so and so conditions, subject to the pendency of the appeal, subject to the dismissal of the appeal, you can ask for the documents back. This is a topic which is covered in most of the provisions of the CPC. Although we are limitedly dealing with Order 12, Order 13, Order 11, but this is a topic, the jurisprudence and essence of which, elements of which are almost covered in most of the provisions of the Civil Procedure Code, as also the Indian Evidence Act. We really do not have that much of time, and this is a topic which can be discussed only with live examples and illustrations. I had heard somewhere that an average person cannot concentrate for more than 45 minutes. We have already covered more than 45 minutes since the time that I have been chatting with you about the provisions and the essence thereof. Probably this is a topic that requires more discussion, more debates, and more illustrations. And We may have it by way of questions and answers if you have any.
If a party fails to produce certain documents in original under Order 11, Rule 14, then what will be the court's discretion?
The court has discretion. The court has discretion to take secondary evidence in place as well. That is as per the Evidence Act. The court has discretion to do that because originals are not always available. Not always available. There may be copies of it. And then when you produce secondary evidence, the provement of that secondary evidence will have to go as per the Indian Evidence Act.
Arjun, the next query is, what is an application for discovery of documents?
Discovery of documents, some documents which are not there in your control or custody, then you can put in an application as per the provisions of the CPC and have discovery of the documents. Not only discovery, all this is particularly dealt with by Order 13 and the rules which are contained therein. Not only discovery, but also inspection, but also production. All this is dealt with very particularly, very minutely by the legislature while drafting Order 13. So discovery, production, inspection are of those documents which we are not in control of or we are not in custody of.
Please specify more about admission in interest and against interest.
Yes, see, suppose there is a will. I'll try to answer it by way of an illustration. Fortunately, I had a meeting just before this webinar in which I was discussing a will matter with a particular client of mine. So there is a particular will in favor of A. In the will, many things have been written in favor of A as also in favor of B. Now I'll tell you who that B is. B happens to be a real relative, a very close relative, such as a son or a daughter of the testator. B comes before the court and says that my mother or father, the testator, never intended to gift this property or give away this property in favor of A, in whose favor actually the will says that the property lies today. But there are certain things in my favor as well. And there are certain things which the will states against A as well. So, insofar as the interest of B goes, he admits it. Insofar as it goes against the interest of simple language, it means partial admission and partial denial. Ultimately, it will depend upon the case whether the issue can be framed on it or whether a decree can be passed with that particular issue or a judgment can be passed with that particular issue. It will depend upon a case. But then for a common judge, a common court, it becomes too difficult. In such kind of situations, it is rather better to frame the issue, have evidence in place, go in for trial, have the parties settled and have the issues settled and thereafter deliver a judgment. That is the most comfortable job in such a situation instead of deciding it then and there as per Order 12.
In the reply notice, defendant admit the terms of an agreement, thereby requesting to proceed with an arbitration, pointing the provision in para 2 in the preliminary objection to defendant accept the execution of particular agreement, but in evidence defendant denies the execution of the said agreement, stating null and void. In such condition, can plaintiff gains the benefit of such contradiction by defendant?
But it will not go to the evidence stage if he admits the execution of it. It will not reach the evidence stage. So tomorrow I agree that at the evidence stage he may deny or it may even get disproved. The execution of it even may get disproved. But it will not reach that stage. You see the point. This is something that we deal with thoroughly before it can reach the evidence stage. So once you file a written statement, you will also have to file a statement, an affidavit of admissions and denials, or either suo moto or either on being called upon to do so. Now, that being the case, you will have to intermeddle with this stage, crossing which you will go to the evidence stage. So here itself, if you agree with the Arbitration Act, you will be relegated by the court to resort to arbitration. The suit is over there. If you agree with the execution of it and the arbitration clause, the existence of it, the suit will not travel to the evidence stage, to my belief.
Can we say that prima facie evidence can be linked to admission during interrogation?
How can it be called evidence in the first place? It's either a document. Now, if it's a document and that prima facie shows, again, it's a prima facie case. How much do you believe on a prima facie document or the prima facie veracity of it, that it will lead to admission of it? See, admission has to be specific. It can be prima facie. It is not a stage of Order 39 Rule 1 where injunction will have to be granted on the prima facie veracity of documents. This is a case of admission. It is either an admitted document or a denied document. There's no midway out of it. So there's no prima facie theory in case of admissions. Either it is admission or it is no admission. Prima facie theory exists only in case of Order 39, where injunctions are to be granted.
If a party produce any document at hearing stage without producing it at initial stage of case, does it affect the case or the admissibility of the document?
See, at any stage, the court has the power to call for a document for admission or for denial. The party doesn't have the power unless a leave to that effect is granted at a later stage to produce this document. Because we live on a common perception that you can't take the other side by a surprise. You can't only bring 10 documents in front of the court, get an injunction, and later at the evidence stage say, oh, sorry, I forgot this was the 11th document which was in my possession. I should have gotten to be. Now, the provisions of law say that if there is a new discovery, by way of research, you have come across something that was not possible at the time of the stage of filing of the written statement or filing of the plaint, then that may be permitted. And then, yes, Order 13, Order 12, Order 11 again will come into existence, that document, where the court or the party can ask the other side that, yes, what do you have to say on this document? If he admits it, so be it. If it is so powerful that it will lead to the dismissal or the decreeing of the suit, then that admission will finish everything, including the suit, or that denial will finish everything, including the suit, either positively or negatively. So coming back to the question, whether it can be produced in such a way, yes, it can be produced, but only subject to certain conditions which I have specified. The court can, of course, ask for it at any point of time. With whether it will affect your case, I don't know what that document is. If it is so powerful that it will go to the root of the matter, then it will definitely affect your case. If you are for the plaintiff and if you are so fortunate, then probably it will get decreed in your favor. If you are for the defendant, and again, if you are fortunate, it will get dismissed, which is again in your favor. You enjoy.
Law of evidence requires only production of documents, which does not necessarily mean filing the original on the record of the court.
Correct. That is one part of it. Filing the original, not filing the original on the record of the court is one part of it. But then it is upon your skill how to make the court believe that that is primary evidence. Let it not be treated as secondary evidence. Because if that is treated so, then the provement of it has a different mechanism. And if it is treated as primary evidence, then the provement of it has a different source altogether. Be that as it may, so far as admission is concerned, we need not worry that much whether it is an original document or a duplicate document. We need not worry that much on the chapter of admission, because admission requires the consent or denial of the other side on the existence of the document, as also the execution of the document, and of course the contents. So he is not going to come and tell the court, oh, this is not original, so I will not admit it. Had it been original, I would have admitted it. No. The issue over here is not whether it is original or duplicate. The issue over here is whether the other side will come before the court and say that, yes, I admit this document. May it be original or duplicate. That's a different topic altogether.
Any concluding remarks from your end, Arjun?
Concluding remarks, I will not speak of the law, but I will speak on a different platform. I will say that all of you, those are interested into litigation or actively conducting litigations, I sincerely pray and request all of you to have your participation, good and quality participation in the trial courts, not because there is less quality of practice in the trial courts, but the actual knowledge and the flow is present in the trial courts. I'm not criticizing the higher judiciary, but the actual law and the working of it can be seen in the trial courts. So you must, as law students, if law students are watching this, you must intern with a trial advocate or a trial judge, maybe the JMFC or senior division, junior division, the district court, etc. Or if you are a practicing advocate, then you make it a point that whenever you get an opportunity, have matters in the trial court, conduct trials, conduct injunction application, conduct exhibits, have such notices sent, because this is the real practice. At least that is my personal perception. Thank you very much.